Hi, good evening, everyone. So, today we will be discussing the topic succession, will, gift, wakaf, and uniform civil code under family law of UGC NET. In the last class, we discussed the maintenance and all about that. So, coming to succession and inheritance. See, succession is actually the devolution of property after death. It means the transfer of property after a person's death. That may be by will, that may be the like testamentary, or through without will, that is intestate. That are the two types of succession. And coming to inheritance, what is the basic difference between succession and inheritance? Inheritance refers to specifically to property devolving by operation of law upon heirs after the ancestor's death. That is called inheritance. Then, hence, inheritance can be like we can call inheritance as a subset of succession. Succession is actually it includes both testamentary and intestate. And coming to inheritance, it is limited to intestate transfer by law. That's a basic concept of succession and inheritance. Then coming on to the scope or the inheritance is actually a broader concept, but coming to succession, it actually means the procedure that is dealing with the inheritance, that is called succession. So inheritance arranges automatically on death, but coming to succession, it may be testamentary or intestate. Okay. So, inheritance is transfer of property, rights or obligation from a deceased to their heirs. But coming to succession, it's actually the legal process by which inheritance takes place that you can see in the slide. Okay. Then the inheritance actually concerns right. Its main focus is to it concerns right. But coming to succession, it concerns the law and order of devolution. Coming to an see, we can take it as an example. Coming to we can take Hindu law. In Hindu law, the son's right in ancestral property. It's actually inheritance distribution under Hindu Succession Act of 1956. It's actually succession. But this Muslim law fixed Quranic shares, it is inheritance, and the allocation of these shares can be called succession. So, Hindu law, the son's right in ancestral property can be called inheritance, and its distribution is succession. And in Muslim law, the fixed Quranic shares are considered inheritance, and its allocation is succession. So, inheritance is what is received. We can call or the meaning of inheritance is what is received, but coming to succession, it is how that inheritance is received, how it is received. That is a basic difference between inheritance and succession. So coming to the UGC NET exam, you have to focus the basic difference between inheritance and succession, and also make a comparative study of what is in Muslim law and what is in Hindu law. Okay. Then intestate succession means, okay, when a person dies without a will, that is intestate succession. Intestate succession occurs when a person dies without making a will, making a valid will. See here, the property devolves as per the personal laws as per that person is concerned. For example, if an Hindu male dying in the street, if an Hindu male dying without will, the law which governed them is Hindu Succession Act of 1956. Okay, and if coming to Muslim law, it will be Quranic shares. That is a basic concept in interstate succession regarding Hindu law and Muslim law. Then coming to testamentary succession. Testamentary succession means when a person leaves a valid will without a before his death, that is also called testament. In this case, the property devolves according to the deceased person's will. Okay. For example, if an Hindu writing a will for his self-acquired property, that is governed under the Indian Succession Act of 1925. That's a basic difference. So Hindu law in this concept, Hindu law recognizes it fully, but coming to Muslim law, it is very limited because regarding testamentary succession, a Muslim male cannot will away more than one third of his estate without the heir's consent. So the UGC net focused the distinction between intestate and testamentary succession from Hindu Succession Act of 1956 and also the Muslim law principles. So that's the basic difference between Hindu law and Muslim law regarding the succession. There will be intestate succession and testamentary succession. Intestate succession is when a person dies without making a valid will, and here it is the property is distributed as per the personal law. In Hindu law, it is Hindu Succession Act, and Muslim law it is Qurani shares, residuaries, and distant kindred. Okay, and coming to testamentary succession, when a person leaves a valid will, that is testamentary succession, and it is recognized fully as per the Hindu law. But coming to Muslim law, in case of testamentary succession, a Muslim cannot will away more than one third of his estate without her heir's consent. Okay. Then we can coming to Hindu Succession Act 1956. We can just look what is succession as per the personal law of Hindus and how it is evolved regarding the persons. See, the governing law is Hindu Succession Act of 1956, otherwise called HSA Act, and here its objective is to codify Hindu succession and ensure equality, especially for women. That's the basic purpose or objective of Hindu Succession Act of 1956. Then coming to interstate succession, interstate succession is governed or explained from section 8 to 13 of the Hindu Succession Act of 1956. Here, the section 8 means the property of a male Hindu divorced first to class first heirs. See, I have mentioned it in the slide. Class first, class second, agnates and cognates. See, class first heirs includes widow, son, daughter, mother, etc. That are the persons or heirs which come under the degree of heirs which come under the class first category. Coming to class second heirs, the class second heirs include father, siblings, and others if no class first heirs exist. Class first, if no class first heirs exist, then others will be considered as class second. So in the class first, there will be widow, son, and daughter, and also the mother. And coming to class second, it will be father, siblings, and others if no class first heirs exist. Okay. That's a class first and class second heirs as per section 8 of the Hindu Succession Act of 1956 when a person dies in the street. Okay. Then coming to agnates and cognates. Agnates is through male lineage. Agnates actually uh, actually means or it expresses the male lineage, while the cognates is through female lineage. That's the basic difference of agnates and cognates. Agnates through male lineage heirship, and cognates means female lineage heirship. Okay, and this agnates and cognates coming to a case, that is Vineet Sharma versus Rakesh Sharma in the year 2020. Here in this case, the Honorable Court held that doctors are co-partners by birth. There were some discrepancy and discrimination regarding this role in the past. We know women's rights were not at all recognized. There exists some kinds of discrepancy and differences and discrimination. So as per the judgment of 2020 in the case Vinesh Sharma versus Rakesh Sharma, the doctors, they are considered as the co-partners by birth. Okay, that's mentioned in Vinesh Sharma versus Rakesh Sharma. And as per section 14 subclause 1 of the act, the female Hindu's property become her absolute property. That's the main thing mentioned in section 14. That is, the female Hindu's property becomes her absolute property. Then coming to section 14 subclause 2, there is an exception. That is, the property granted for restricted purpose remain limited. If a property is granted for a restricted purpose, then its rights will be limited. that is mentioned in section 14 subclause 2 of Hindu Succession Act of 1956. That's all about that's all about the succession regarding industry. Then coming to testamentary succession, and Hindu can make a valid will for self-acquired property under the Indian Succession Act of 1925. That's basically on the self-acquired property of the male. Okay. Then coming to Muslim law of inheritance. See, the sources of Muslim law of inheritance we can take Quran, Sunnah, Ijma, Qiyas. These are considered as the sources of Muslim law of inheritance, and there are some principles which is based on that. First one is no joint family or co-partnership system exists in the case of Muslim law. Okay, there is no joint family concept. Then next is both males and females are legal heirs, though shares differ. Under the Muslim law of inheritance recognized both male and female as the legal heirs, but their shares, the proportion or the proportion regarding the shares, it will be different for a male woman under Muslim law. Sorry, a woman under Muslim law and a male under Muslim law. That's a basic difference regarding the shares. Okay. Then the rule is nearer in degree excludes the remoter. So the person who are nearer in degree, they will exclude the remoter degrees. That's a basic rule or principle as far as the Muslim law of inheritance is concerned. Then coming to the hairs, the type of hairs as per the Muslim law. As per the Muslim, the type of hairs they are considered as three. That is, the first one is sharers. They are the fixed sharers, like the spouse, parents, children. They are considered as the fixed sharers. That they are called sharers. Then coming to second category, that is residuaries. Residuaries also called as asaba, otherwise called asaba as per the Muslim law. They are considered they are the people who get the share what is remaining. So they take what is remaining in the share. They are called residuaries. Then the third is distant kindred, the distant families. They will inherit if no sharer or residuary exists. So we have seen the classification as per the Hindu law, that is class first were widow, son, daughter and mother exists. The class second is father and siblings and others if no class possesses. Then agnates are for the male lineage and the cognates are called a female lineage. That's all about in the Hindu law of interstate succession. Then coming to Muslim law of interstate succession, coming to the Muslim law, these decrees are, first one is sharers. Sharers include the spouse, parents and children, and residuaries. Residuaries otherwise called asaba. They get the share what is remaining in the share after the sharers. And distant kindred, they will inherit the property if there is no sharers or residuaries. That's the case in Muslim law. Okay. There is a case called Muhammad Ahmad Khan versus Shabano Begum in 1985, which is a landmark and classic case regarding the law of inheritance and also in Muslim law. In this case, it actually recognized women's economic rights. In this case law or this judgment, first initially, or actually a stepping stone to the empowerment of women as per the Muslim community is concerned. In this case, the women's economic rights were recognized and it emphasized women's financial rights post-divorce connected to the inheritance equality. That's a main case law which we have to remain in mind. We have to see, you have to go through this case. You have to remind the citation, the main judgment, the quorum of that particular case. All this you have to remind because it's a very important case regarding the Muslim law and also coming to the inheritance. Then we can now looking on to the will. or otherwise called wasiyat as per the uh, wasiyat as per the law. See, will or wasiyat. It's actually a legal declaration of property disposal after death. It's actually a legal declaration of property. Okay. So, will is a legal declaration by which a person dispose of his property after death. As per Hindu law is concerned, it is recognized or it is governed by the Indian Succession Act of 1925. As per this, any adult of sound mind can make a will. It can be revoked before his death. Okay. So, as per the Indian Succession Act of 1925, any adult of sound mind can make a will and it can be revoked before death. Okay. That's as per the Hindu law. Then coming to the Muslim law, a Muslim male can dispose of one third of his property by will without heirs' consent. Beyond that, the consent of heirs is required. Only one third of the property he can, only within that one third of property he can make a will. Other he have to make will with the consent of the heirs. Okay, it can be oral or written, and attestation is not essential as per the Muslim law. So there is a case called Abdul Manan Khan versus Mirza Khan in the year 1991. In this case, it is upheld one third limitation. This case upheld the one third limitation as far as the testamentary succession or regarding the Muslim law. Okay, I hope my voice is clear for you. So then coming on to the gift, we can now moving on to the gift. Will we have already discussed the Hindu law? It is basically governed by Indian Succession Act of 1925, and regarding the Muslim law, as per the case Abdul Manan Khan versus Mirza Khan in the year 1991, which upheld the 130 limitation of property coming to the testamentary succession. Okay, then going with gift. Gift, otherwise called hiba. Okay, gift is actually a voluntary transfer of property without consideration. It is actually the voluntary transfer of property without consideration. It is a transfer without consideration, and there are some essential regarding the gift or to constitute a gift. This should be needed. First one is declaration, second one is acceptance, and third one is delivery of the possession. One have to declare that and see A is giving gift, that we have to accept it, and also there should be delivery of possession of that particular property from A to B. That is called the essential ingredient as far as a gift is concerned. And under Muslim law, there should be a declaration by the donor, and there should be a acceptance by the donee. Sorry, and the third condition is there should be a delivery of possession. That is all about gift under Muslim law. And in the case Abdul Rahim versus SK Abdul Sabar in the 2009, in this case it is felt that the delivery of possession is essential for constitute a gift under the Muslim law. Okay. Then coming to Hindu law, this concept like concept of gift is governed by the Transfer of Property Act of 1882, and it is explained from section 122 to 129 of the Transfer of Property Act 1882. And as per this, the registration is needed for immovable property. We have seen that coming to the gift under Muslim law, it's a voluntary transfer property without consideration, and we have seen some of the conditions also. So coming to the Hindu law, the registration is needed for immovable property. Okay, so that's all about gift. So far we have discussed this like succession and inheritance, the basic difference. Then we have discussed the interstate and testamentary succession. Then we discussed this like Hindu Succession Act of 1950s is what is the inheritance, what uh, how is inheritance regarding Hindu law is concerned and Muslim law is concerned. Then we discuss will, otherwise called wasiyat, and also gift, otherwise called hiba. Then moving on to the another basic and important topic, that is wakaf. See, wakaf, actually literal meaning is called detention, and it's coming to wakaf. What is wakaf? It's actually a permanent dedication of property by a Muslim for pious or charitable purpose. It is actually a permanent dedication of properties, particularly its main motive is religious. Okay. Then once a wakaf is made, it is permanent, it is irrecoverable and also inalienable. It is complete and it is unconditional. Once a condition is made regarding wakaf, then it is not a valid wakaf. Okay. And the ownership of dedicated property is taken away from the person who is making wakaf. A person who is making a wakaf is called wakif. In wakaf, that I is not present. Coming to wakif, wakif. So a person who is making wakaf is called wakif. So regarding wakaf, the ownership of the dedicated property is taken away from the person who is making the wakaf and it is transferred and detained by the court. Okay, that is all about wakaf. There are two types of wakaf, that is public and private wakaf. Coming to public wakaf, it is for exclusively for the community use, and coming to private wakaf, otherwise called wakaf alal aulad, it is actually for family or the remainder for charity. Its main objective is that. And regarding Wakaf, the main statute which is governed Wakaf is Wakaf Act of 1995. And in the case Muhammad Ismail versus Takur Sabir Ali in the year 1968, it is held that Wakaf is actually a reinforced perpetuity. It is complete, it is permanent. And in the case of Abdul Fattah Muhammad Ishaq versus Rusomi Dur Chowdhury in the year 1894. Here in this case it is held that validated the family wakaf concept. Okay, that's all about wakaf, and we have wakaf is actually a very important topic. So coming to the essential condition, I have already discussed and we have gone through that condition, but to highlight there is actually a permanent dedication. A motive is completely religious. It's a religious motive and it's completely for the benefit of the Muslim community. And once made, it is complete, it is unconditional, and it is not for a limited period. Otherwise, it will be invalid. So, as I already said, is this wakaf, it is inalienable and irrecoverable. Okay, that's the main concept regarding wakaf. Then coming to the competency of wakif. Wakif means a person who is making the wakaf. One whose property is taken away. That person is called wakif, and he had transferred and detained his property for God. Okay, so he should be majority. The wakif, if this concept of this condition are satisfied, then it will constitute a valid wakif. So soundness and majority is required regarding a wakif is concerned. Okay. Then also one more thing, the right to make wakaf. See, the person who is wakif, he have to dedicate his entire property, and he should have a legal property to transfer that particular property for wakif or transfer his title. So that person should have the real ownership and title of that particular property. Then and only that person can dedicate that property for religious or charitable purpose. So that that person should have a right to make wakaf. Okay. So first we have discussed the soundness, then majority, and also the right to make wakaf. That is very important regarding this concept is concerned. Okay. Then one more thing, a widow cannot see, a widow cannot give a property to wakaf even if she have an unpaid dower. It is not considered as a valid wakaf since she is not considered the absolute owner of such unpaid dower. So, in that sense, a widow cannot transfer his property to wakaf. Okay. Then coming to testamentary wakaf, we have already discussed the testamentary succession, and in this we have dealt that only 1/3 of the property can be given as per testamentary succession, and others it need the consent of the heirs. So here regarding the testamentary wakaf, only 1/3 of the property can be given. That is mentioned. So the valid object of the wakaf is to maintain the poor. for the welfare of the Muslim community, and it's absolutely religious. It's absolutely, if it is secular, then it is for poor, maintaining the poor person. So it's completely religious, and its motive is religious. That's it. That's all. Then coming to the creation, how a wakaf can be created. See, a wakaf can be created by the act of wakif, or otherwise by a will, and also by usage. If that particular property is being used by the wakaf for the welfare of the Muslim community, and for completely for religious or charitable purpose for time immemorial, then that particular property belongs to wakaf as per the usage. So wakaf can be created by the act of the person, by usage, and also by will. So that's about wakaf. Then what is the legal consequence regarding this wakaf? See, if someone has dedicated this property for religious or charitable purpose, then that property is considered detained by God. Then that property belongs to the God, and also it's permanent. It once made, it is irrecoverable and also inalienable. And it's completely for religious purpose and pious or for charitable purpose. That's all about wakaf. Then one who managed the wakaf is called mutawali. That's a word or phrase for one who manages the wakaf. In most cases, the mutawali be the wakif, or otherwise, once a person has to be responsible or to be appointed to be a mutawali. But coming to mutawali, he is not the owner. He don't have the absolute right over the property. He is just a superintendent to take care the property and to check whether the beneficiary, whether the object of that particular wakaf is satisfied, whether the beneficiaries get the benefit of that wakaf property. That's all the responsibility, or that's the main job, or the one and only job of the mutawali, and he do not have any right to alienate the property or to supervise. Is not a person like that. He do not have the absolute property. He is not the owner of property. He just take care the property and to check whether the intended beneficiaries are benefiting from this wakaf property. And he will be appointed by wakif in some cases, or in other case he will be appointed by other. And yeah, if a mutawali is appointed, he will be removed by the order of the court, or by the Waqf board, or by the Waqif. He can be removed in three manners, like by Waqif itself, or by the order of the court, or by the Waqf board. Okay. Then coming to Waqf, you know that regarding this Waqf, there are several controversy in this year. They say Waqf Amendment Act of 2025 uh, still filled with lots of controversy. It's actually the main intention of is to have a good governance, good transparency, accountability. That's actually the main uh, aim or main object of that particular act, and it is still in dispute. And there are some disputes regarding that, if that Waqf board management or its decision is taken by the government. That's a like one of the suggestions made by the, or one of the main points as per the new amendment act of 2025, but is still in dispute. I have just mentioned what is the dispute. I am not supporting or not like against that particular law. I'm just mentioning there is a, like, there is an update regarding this Waqf, and this happened during this time. So it is still in dispute regarding the governance management. All these topics are still in dispute. Okay, so that's about Waqf. Waqf is actually a very important topic, and see, since there is lot of dispute regarding topic, and even now it is not sorted, so there will be chance of asking question regarding this Waqf. So you have to go through this current affair, you have to go through the newspapers, you have to go to the authentic sites and sources where you will get the valid information regarding this, and you have to remind this also. Okay, so that's all about Waqf. Then coming to Uniform Civil Code, UCC. See, As per Article 44 of Directive Principles of State Policy, it is that the state shall endeavor to secure a uniform civil code. Actually, its main aim is equality, gender justice, and national integration. That it's have no doubt. So, this is actually the main goal or main object of Uniform Civil Code. It to promote the unity and gender equality, to harmonize the diverse personal laws. See, we have diverse personal laws for Hindus, for Christians, for Muslims. We have diverse Hindu laws, and there are some discrepancy and like like some differences and some discrimination regarding this. So we need a uniform civil code regarding that. So main aim is gender justice and equality and nothing more. So, coming to its judicial perspective, when we coming to the judicial perspective of Uniform Civil Code, we have Mohammed Ahmad Khan versus Shah Bano Begum in the case of 1985, which urged the UCC for women's rights. We have discussed that it is the right in which the economic security or economic condition of women is addressed regarding this inheritance post divorce. So that is called Muhammad Ahmad Khan versus Shahana Begum. Then coming to Sarla Mughal versus Union of India, which prevent the misuse of conversion. We have seen that in the we have discussed and we have studied that particular case, Sarla Mughal versus Union of India, which prevent the misuse of conversion. And there's another case, that is John Valamattam versus Union of India in the year 2003, in which it struck down the discriminatory provision regarding this. And also Sharabanu versus Union of India 2030, which declared the triple talaq unconstitutional. So these are actually a stepping stone for uniform civil code. This all motives for a uniform civil code. Okay. Then coming to this, what is the present status of Uniform Civil Code is Goa is follows the Portuguese Civil Code of 1867. It's the only state in which UCC active or UCC in force. The UCC remains a directive principle which is not enforceable. See, it has some for implementing UCC, it has some challenges and contemporary issues. I hope you are well aware of them, and just pointing out some of the reasons which we all know, because that's not practical to implement this. There should be social questioning regarding that. We have some religious diversity and cultural pluralism, and the society, the religious freedom. uh, uh, See, India is a secular country where there are so many religions, and anyone can practice any religion which he or she wish to. So in every religion there are some principles, some conditions. So no one is we can't step back, or we can step up to a to uniform civil code easily. So we know there are some problems regarding that. So first, coming to the challenges and contemporary issues. First is religious diversity and cultural pluralism. So, then second one is fear of eroding religious freedom, and the third one is need for gradual and inclusive implementation. As I already said, it cannot be implemented by a night. That need to be gradually implemented. Gradual and inclusive implementation is needed. We have to change we need to make some amendments in the act, and in that case we can slowly get into uniform civil code without sorry without violating or curtailing in any religious belief of the person. And we know uniform civil code is necessary since we have discussed that gender justice. Women should have equality, men should have equality, even men or women, any other gender. We know other genders are recognized in our society now. So every gender needs equality, whether male, female, transgender, or any gender. They need equality. They needs equality in every process, in criminal trial, in criminal cases, in civil cases. In any cases, we need equality. So uniform civil code is a vast area. It's actually cannot be taken. It needs a one class or two class discussion. That's a very wide topic. So that's all about uniform civil code. Now we have discussed the challenges also. Then a case summary. See, this is actually a summary. I am going to summarize what I thought in today's class. See, first we have discussed the succession, and in this case, Vinesh Sharma in the year 2020, we have discussed that, and we have seen that there is equal co-personal rights for daughters as per this case. And coming to the female properties in the case of Tulasamma versus Shesha Reddy in 1977, here we see that women's absolute ownership regarding the property. Then coming to Muslim law inheritance, the Muslim law inheritance, we have seen that Shabano was in 1985 where economic security or women's financial right is recognized. Then coming to the gift, that is based on Muslim inheritance. Then coming to gift, that is Abdul Rahim in the year 2009, which means that the delivery of the possession have to be delivered, which is mandatory regarding if gift is concerned or to constitute a gift. Then coming to will. Will Abdul Manan Khan versus 1990 in the year 1991 regarding the will, it is the one-third rule regarding the Muslim law of inheritance. If one as per the testamentary succession or the testamentary will, a Muslim male can make will regarding this 1/3 of his property. For making will from the for the other remaining property, he needs the consent of the heirs. That is held in the case Abdul Manan Khan. Okay. And in regarding the Waqf, there is a case called Abdul Fatah in the year 1894, where it recognized the family Waqf validity. And at last, we discussed the UPSC, that is Uniform Civil Code, Sarla Mudgal versus 1995, which urged the need of national code or the urge for uniformity or for uniform civil code. So that are the topics we have discussed so far. First, we have discussed the concept of succession and inheritance. Succession means we have seen that it's actually a devolution of property after death. And here we see that succession is actually a legal process by which inheritance takes place. So succession actually operates, it may be testamentary or intestate. But in coming to inheritance, it's actually the transfer of property, rights or obligation from a deceased to their heirs. So it's actually arises automatically in the on death. And coming to the inheritance, it's a very broader topic. Coming to its scope, it's a very broader topic. But regarding succession, it actually deals with the procedure. And regarding this, there is testamentary when a person dies by making a will, and intestate when a person dies without will, that is intestated. Okay, that we have discussed, and we have seen that the inheritance concerns the right, but coming to succession, it actually the procedures. It concerns law. It concerns law and order more. Okay, that we have seen, and we have discussed the we have discussed it with an example like in Hindu law, the son's rights in ancestral property, it is considered as inheritance, but it's a distribution as per the governing law. But like the Hindu Succession Act of 1956, that is called succession. Then coming to Muslim law, the fixed Quranic shares, this is considered inheritance. But coming to its allocation of these shares to sharers, residuaries, or distant kinship, that is called succession. So inheritance is what is received. It operates automatically after death. But succession is how it is received. How it is received, that is dealt in succession. Okay. Then we have discussed this interstate succession and testamentary succession from Hindu law and Muslim law. In Hindu law, we have discussed that there is class first, that is widow, son, daughter, mother, and coming to class second, it is father and siblings, and Agnes is the male lineage and Cognates is the female lineage. And then coming to section 14 subclause 1, regarding the female, their property is considered absolute. That is also held like in Vinit Sharma versus Rakesh Sharma in the case 2020 we have discussed. Here the doctors are co-partners by birth. And also in Tulasima versus Shesha Reddy in 1977, it actually recognized the woman's property rights. So that's all about Hindu Succession Act. Then coming to Muslim law of inheritance, there are three categories. That is, the first one is sharers, second one is successors, and third one is distant kinship. Okay, and here in Muslim law there is no joint family concept. It's only talk about the nearer in degree excludes the remoter. And also as per we have discussed the case Shabano case in the year 1985, in which the woman's economic rights or economic security regarding the financial security post divorce, it is recognized in as per this case. And we have discussed the will. Regarding the will, it's actually a legal declaration of property of disposal after death, and it is held in Hindu laws per Indian Succession Act of 1925. And coming to Muslim, only one third of the property he can make will without the heir's consent. So that's held in will. Then regarding the gift, it is transferred without consideration, and we have discussed its essentials like declaration, acceptance, and delivery of question. And coming to Muslim law also, there is declaration by the donor, acceptance by the donee, and also delivery of the possession. This Abdul Rahim versus S.K. Abdul Sabar of 2009. This case mentions the need or the like the want of delivery of possession regarding the essential to constitute a valid gift or valid hiba. And coming to Hindu law, it actually governed in the Transfer of Property Act of 1882. And also here it is in the case of immovable property, registration is compulsory. That's held in this. And Wakaf, we have already gone detailed in that topic. See, Wakaf, its meaning is retention, and it's actually a permanent dedication of property for religious or charitable purpose. Its main motive is completely religious, and once made, it is irrevocable and also complete. It is inalienable. And one whose property is taken away from the from and make it as wakaf or transfer and retained by court, that person is called wakif. And here it constitutes for valid wakaf to take place. That wakif should be sound minded, he should be major, and he should have a right to wakaf. He should have legal right, he should have title and ownership of that particular property. And the basic concept of this is to maintain the poor and for the welfare of the Muslim community, that is for the wakaf is made. And for Wakaf to manage all this, there is a manager who is called Mutawali, and he will be appointed by Wakif or by like Wakaf board or another, and he is removed by Wakif by court or by the Wakif board. And also he do not have the absolute right of the property. He is just managing the property and to check whether all for whatever purpose this Wakaf is created, if that is fulfilled or not. That is actually mentioned, or that is actually uh, uh, like looked after by this Mutawali. So that's all about Wakaf, and we know that there is still an issue or which is a controversy that is still in dispute regarding the Wakaf Amendment Act of 2025, regarding its governance, regarding its transparency, its accountability, what happens if it is governed by the government, and what if it is Wakaf board. So there are some controversy and like uh, issues regarding this. So you have to understand that fully, because there are chances of asking questions regarding this area. Then coming to the Uniform Civil Code, we know it is mentioned under Article 44. It's considered directive principles of state policy, and its main intent is to equality and gender justice. That's its main intent. And for national integration, we know there exists some discrepancy regarding this. And yeah, Goa is the only state with implemented UCC. And we have already discussed what's the problem regarding its implementation, the challenges and the contemporary issues. And we have discussed the key case laws which discuss regarding succession, female property, gift, UCC, will, Wakaf. All these, there are some landmark cases we have discussed. Then coming to the questions, I need answers from you regarding these questions. Let me check whether you have any doubts regarding this. See, this is what we have dealt or we have discussed so far. This is the uh, this this is all about what we have discussed so far. So, under which section of the Hindu Succession Act a Hindu woman's property become absolute? We have discussed it in section 14, subclause 1 of the Act. See, section 14, subclause 1 of the Act giving absolute ownership to Hindu woman regarding a property, and which is the case which pronounced the one-third rule, and in which context. See, the one-third rule is coming from this case, like we know Abdul Manam Khan, the year 1991. And for constituting a valid hiba, we know there should be a declaration by the donee and acceptance by the donor, and also the delivery. The delivery of possession is uh, crucial, or it's actually very important as per the case Abdul Rahim in the year 2009. And coming to the constitutional basis of UCC, we have discussed this. It is mentioned in Article 44, and its main intent is, we have discussed equality, gender justice, and national integration. Okay. Then coming to last, that is which state follow UCC. We know we have discussed the Goa is the only state where UCC is still practicing, or which have implemented this. So that's all about the topic we have discussed so far. We discussed like succession, its basic difference from inheritance, will, gift, wakaf, and uniform civil code. So that's all about today class. I hope you have a clarity about what to study regarding this UGC NET exam. As per the Unit 7 of UGC NET, these are the very last topic which is mentioned in the syllabus. And the first is like sources and schools of law, family law, and the marriages concept that we can take in other class. So this is all about family law concept. Now in next class we can come with another subject in the syllabus, and I have actually given a brief idea, a nutshell. In a nutshell, I have discussed every concept. You have to gone through with the Bayrat. You have to study. See, regarding the section, you need to take Hindu Succession Act of 19. See, so 1955 Act, no? Sorry, 1956. You have to take this 1956 into succession act, and you have to go through each section. So see, there will be questions asking regarding the sections, regarding the case law, its citation, regarding the concept or regarding the theory. You should have a clarity regarding that, and all other questions will be asked, which will be twisting or confusing. But see, regarding this, you have to maybe you may be asked to arrange the cases in a chronological order, or regarding the citation, regarding the section. So you have to first study a particular section, what it is mentioned in that particular section, the connected case laws in that section, and the main any contemporary issues or uh, affairs regarding this. Like if, for example, if Wakaf is concerned, if you have contemporary issue, it is still in dispute, it is controversy. So all this you have to connect with. You have to connect that basic concept to that section to and connect it to a case, and also the current situation you have to analyze. Only that you have to only that you can crack that particular exam, because it is the pattern of the questions will be asked in such a manner which will make you confused. So the question papers we can discuss it in the later class. We will be discussing it but like very detailed. We will be discussing each questions regarding each syllabus of each topic in the UGC net syllabus. So we can come with another class from the next day. So thank you for joining the section. I hope you don't have any doubt regarding this session. If any doubt has, you can please do comment, then I can clear it. So thank you for the